The leather on the courtroom bench was cracked and cold, even through my jeans. I'd been sitting there for 11 minutes, watching the man across the aisle lean over to whisper something to his lawyer. Then they both looked at me. Then they smiled. I kept my eyes straight ahead. My name is Frank Holloway. I'm 64 years old. I drove to that courthouse in a 2009 Ford F-150 with a cracked side mirror and a heater that only worked on the passenger side. I was wearing the same flannel shirt I'd worn to my son's funeral 3 years before. I wore it on purpose. I want to tell you what happened in that courtroom. But to understand it, you need to understand what I lost and what I spent the last 2 years doing about it. My son, James, died on a Tuesday morning in March. He was 37. An aneurysm, sudden and without warning, the kind that gives you no time to say goodbye. James had been a structural inspector for the city of Columbus, Ohio. Steady work, honest work, the kind he took seriously. He left behind a 10-year-old boy named Tyler and a wife named Sandra who, within 8 months of burying her husband, had moved a man named Derek Ashworth into the house my son had paid for. I won't tell you I liked Sandra before all this. She and James had a complicated marriage. She spent money faster than he made it. She traveled for work more than seemed necessary, and the few times I visited, there was a coldness in that house that had nothing to do with the thermostat. But James loved her, and Tyler loved his mother, and so I kept my opinions to myself because that's what you do. When James died, I became Tyler's primary stability. Sandra worked long hours. Derek, who came along fast enough to make your head spin, had no interest in a 10-year-old boy who looked exactly like the man who came before him. Tyler started calling me on weekends, then weeknights, then at odd hours, just to talk, just to hear a familiar voice. We'd go fishing at Hoover Reservoir on Saturdays. I taught him how to change a tire. We watched football together on a second-hand couch in my living room and ate frozen pizza, and it was the best part of my week. Then Sandra told me she and Derek were relocating to Phoenix. Derek owned 4 restaurants in the Columbus area, upscale places, the kind with small portions and large prices. He decided to expand to Arizona. Sandra would go with him, and Tyler, of course, would go with Sandra. I hired a family law attorney named Patricia Oakes. Good woman, 20 years of experience, sharp as anyone I've ever known. She filed for visitation rights. Sandra's response was to file for sole legal custody with a relocation petition, asking the court to allow her to move Tyler 800 miles away and to restrict my visitation to 2 weeks per summer and every other Christmas. Derek's attorney was a man named Gerald Caldwell. His suits probably cost more than my truck. He had the smooth, unhurried confidence of a man who had never once in his professional life needed to worry about the outcome of anything. From the moment I first saw him in that hallway outside the courtroom, he looked at me the way a man looks at something that's wandered in from outside and doesn't belong. "Mr. Holloway," he said to me during a pre-hearing conference, not even glancing up from his legal pad. "I want you to understand that our intention is not to remove you entirely from Tyler's life. We simply believe that a stable 2-parent household in Phoenix offers the child opportunities that he paused here, let his eyes travel once across my flannel shirt and my cracked work boots, a retired grandfather on a fixed income in Columbus simply cannot match." I said, "I understand." He looked up then, a little surprised, I think, that I hadn't argued. "Good," he said. He didn't know what I'd been doing for the past 22 months. I should explain something about my career. I spent 28 years as a special agent with the IRS Criminal Investigation Division. If you don't know what that means, it means I spent nearly 3 decades following money, tracking it through shell companies and dummy invoices and falsified payroll records and offshore transfers and all the other creative ways that people who have more than they deserve try to keep what they've taken. I was good at it. I retired at 62 with a commendation from the field office director and a quiet handshake from people whose names I'm still not supposed to mention in certain contexts. When I retired, I thought I was done with all of that. I thought I'd fish and watch Tyler grow up and maybe take a trip to see my sister in Vermont. Then Derek Ashworth moved into my son's house, and I started paying attention. It started small. Nothing I could point to directly, just the instinct you develop after nearly 3 decades of doing what I did. Derek's restaurants were busy but not extraordinary. The locations were good but not exceptional. Yet within 18 months of my son's death, Derek had purchased a second home in Scottsdale, leased a $94,000 SUV, and was making preliminary offers on restaurant properties in Phoenix valued at over $2 million. Sandra had mentioned, casually, that Derek had investors. She said it the way people say it when they don't actually know what it means. I started watching. I wasn't acting in any official capacity. I was a retired civilian. But I still knew people. And I still knew how to read a paper trail. I want to be clear about something. I didn't do any of this to hurt Sandra. I didn't do it out of anger or grief or spite. I did it because my grandson was going to be living with this man, sleeping under his roof, eating at his table. And something was wrong. I could feel it the way you feel weather changing before you see it. Over the course of about 8 months, through public records requests and conversations with former colleagues who were still active and some careful observation of Derek's business filings, a picture began to emerge. Derek's restaurant group had a small army of vendors, linen suppliers, produce distributors, equipment leasing companies, many of which were LLCs registered to addresses that didn't match any real business location. Money was going out to these vendors in amounts that were just under the thresholds that trigger automatic review. It was coming back through what appeared to be a management consulting firm registered in Delaware. It was a structure I'd seen before. I'd helped put 3 people in federal prison for structures like it. I didn't take this to a lawyer. I didn't post about it. I contacted a former colleague of mine at the Cincinnati field office, a woman named Donna Reese, who I'd worked with for 11 years and trusted with my life. I handed her everything I had, compiled, neatly organized, properly sourced, exactly the way I'd been trained to prepare a referral package. Then I waited. Donna called me 4 months later. She said, "Frank, I can't tell you much, but I can tell you that what you sent us was enough to open something." That's all I can say. That was enough. The hearing was set for a Thursday morning in October. Judge Patricia Morse presiding Family Court, Franklin County. I'd looked her up. 17 years on the bench, reputation for being patient and thorough and hard to fool. I felt good about her. I drove to the courthouse alone. Patricia Oakes met me outside on the steps, looking over my outfit with a slightly pained expression. "Frank," she said carefully. "I know," I said. "You look like you're going to clean gutters." "I know that too." She thought about pressing the point. She decided not to. We'd talked enough over the previous months that she understood, at least partially, that I tended to do things in a particular order and for particular reasons. Inside, the courtroom was smaller than I expected. Dark wood paneling, fluorescent lighting that did nobody any favors, rows of padded benches that had seen better decades. Sandra sat at the petitioner's table with Gerald Caldwell, who was already arranging documents with the practiced efficiency of a man billing by the quarter hour. Derek sat in the gallery, 1 row back, wearing a charcoal suit and a watch that caught the light every time he moved his wrist. Tyler was not present. The court had arranged for his testimony to be taken separately through a child advocate. I was grateful for that. I didn't want him to see any of what was coming. Sandra looked at me when I walked in. She looked at my shirt. She looked away quickly, but not before I saw something flicker across her face. Not contempt, something more complicated than that. Maybe the beginning of an understanding that she was going to feel badly about later. Derek looked at me and smiled. It was the kind of smile you aim at something you've already decided doesn't matter. We stood when Judge Morse entered. She settled in, reviewed something in front of her, and then looked up with the calm, measuring expression of someone who has heard every version of every story and is in no hurry. "We're here today on the matter of Holloway versus Holloway," she said. "Petitioner's motion for sole legal and physical custody with court approval for out-of-state relocation and respondent's cross-petition for visitation rights. Mr. Caldwell, your client may proceed." Gerald Caldwell was good. I'll give him that. He spent the next 45 minutes constructing a careful, polished argument about stability and opportunity and the undeniable advantages of a two-income household with professional careers and a new home in a good school district. He spoke about Tyler's emotional needs and the importance of continuity with his mother. He was measured and reasonable, and he made it all sound completely obvious. Then he talked about me. "Your Honor," he said, his tone shifting to something gently sympathetic. "The way a doctor sounds when delivering news you're not going to enjoy. We don't question Mr. Holloway's affection for his grandson. That isn't in dispute. What is in dispute is whether the court should allow that affection, however genuine, to override Tyler's right to grow up in a home with consistent resources, professional opportunity, and two engaged parents." He looked at his notes. Mr. Holloway is 64 years old. He is retired and living on a government pension and modest savings. He resides in a home valued at approximately $187,000 in a neighborhood where the public schools' test scores are in the bottom quartile of Franklin County. He has no professional skills applicable to Tyler's current academic needs, no ability to fund extracurricular development, and he paused here, and I heard it coming the way you hear a car backfire before you understand what it is. He appeared here today, before this court, wearing work clothes that suggest a man who perhaps did not consider this proceeding worthy of preparation. He let that sit for a moment. Across the aisle, I heard Derek exhale through his nose. The kind of exhale that isn't quite a laugh but wants to be. Patricia Oakes started to stand. I put my hand on her arm and she sat back down. Judge Morse was watching me. I kept my expression the way I'd trained myself to keep it across 28 years of interviews and depositions and testimony: open, neutral, present, revealing nothing. "Mr. Caldwell," Judge Morse said, and there was something careful in her voice. "I'll ask you to focus your remarks on the legal arguments rather than the opposing party's wardrobe." "Of course, Your Honor." "I apologize." He didn't look apologetic. He looked like a man who had made exactly the point he intended to make and was happy to apologize for it. Patricia Oakes presented our side. She talked about the documented role I'd played in Tyler's life since James died. She entered into the record the messages Tyler had sent me, the school drawings he'd given me, the statements from his teacher and his pediatrician attesting to the stability our relationship had provided during the hardest years of his young life. She talked about what it would mean for a grieving boy to lose the last direct connection to his father. She was good too. When she finished, Judge Morse looked at me directly for the first time. "Mr. Holloway," she said, "I have a few questions for you before we proceed." "Yes, Your Honor." "Can you tell the court about your professional background?" "For the record." I heard Gerald Caldwell shift in his chair. This had not been on his agenda. I said, "Your Honor, my full name is Francis Raymond Holloway. I retired approximately 2 years ago after 28 years of service as a special agent with the Criminal Investigation Division of the Internal Revenue Service. My final posting was as a senior agent with the Columbus Field Office. My primary responsibilities throughout my career involved the investigation and prosecution of complex financial crimes, tax fraud, money laundering, structured transactions, and related federal offenses. I hold a bachelor's degree in accounting from Ohio State and a master's degree in forensic finance from the University of Dayton. I've testified as an expert witness in federal court on 41 occasions. The courtroom was quiet. I mean genuinely quiet. The kind of quiet where you become aware of the ventilation system. Judge Morse had not written anything down. She was looking at me with an expression that I recognized it was the expression of someone rapidly recalibrating. Gerald Caldwell said, "Your Honor, with all due respect, Mr. Holloway's prior employment has no bearing on." "Mr. Caldwell," Judge Morse said, without looking at him, "I'll let you know what has bearing." She looked back at me. "Mr. Holloway, is there anything else you'd like the court to be aware of at this time?" This was the moment. I'd thought about it for months, how to do it, whether to do it, what it would mean for Tyler, for Sandra, for all of it. I'd lost sleep over it. Then I thought about Tyler calling me on a Wednesday night, his voice smaller than usual, telling me that Derek had said something to him at dinner, that he'd told Tyler that his grandfather was the past and Phoenix was the future. That Tyler had cried a little telling me this and then apologized for crying. He was 10 years old and he apologized for crying because the man living in his house had made him feel like crying was something to be ashamed of. I reached into the inside pocket of my flannel shirt and removed a sealed envelope. Standard business size, white, no markings on the outside except a case reference number in the upper left corner that I knew would mean something to the right set of eyes. "Your Honor," I said, "I'd like to submit this document to the court." Patricia Oakes, to her enormous credit, did not react. We had discussed this. She knew what was in the envelope in general terms, though not in specifics, because I'd wanted her to maintain appropriate distance from the details until the proper moment. The bailiff carried the envelope to Judge Morse. She examined the outside of it. Her expression didn't change, but she reached for it carefully. The way you reach for something when your instincts have told you to pay attention. She opened it and read. It took her about 90 seconds. I watched her read it twice. What was in that envelope was a letter on official U.S. Department of Justice letterhead, signed by an assistant United States attorney in the Southern District of Ohio, confirming that an active federal investigation had been opened based on referral materials related to potential money laundering activity connected to a restaurant group operating under the name Ashworth Hospitality Group, LLC. The letter did not name Derek specifically, but the case number matched the referral I had submitted to Donna Reese 14 months earlier. It also noted that the investigation was at a stage where certain individuals connected to the business might be subject to asset freeze orders in the coming weeks. Donna had not sent me that letter. I want to be clear about that. It had come through proper channels, from the AUSA's office, addressed to me in my capacity as the originating civilian source of the referral. I was entitled to that notification. I had asked for it specifically and carefully and through the correct process, because I had spent 28 years understanding exactly what the correct process looked like. Judge Morse set the letter down. She looked at Gerald Caldwell. Then she looked past him, into the gallery, at Derek. Derek had been watching her read. He couldn't see what was in the letter from where he was sitting, but he could read the room. I watched him read it. I watched his expression do something complicated and unpleasant, the way water looks right before it goes down a drain. "Mr. Caldwell," Judge Morse said, her voice entirely level, "I'm going to call a recess. I need to make a phone call. We'll reconvene in 30 minutes. She stood. The bailiff escorted her out. Gerald Caldwell turned to look at me for the first time since I'd spoken. He had the careful, recalculated expression of a man who has just walked into a room and realized it's a different room than he thought it was. I looked back at him pleasantly and said nothing. Sandra had turned around in her chair. She was looking at Derek, who had leaned forward with his elbows on his knees, his head down, speaking in a low voice to someone on his phone. I watched Sandra watch him. I watched her understand, slowly and then all at once. Something she had probably been choosing not to understand for a long time. There's no satisfaction in that moment. I want to say that clearly. There is nothing in you that feels good when you watch someone's world rearrange itself. She had lost James. Whatever mistakes she'd made after that, whatever poor judgment and whatever willful blindness, she had lost James. And she had a son who had lost his father, and none of the rest of it changed those facts. I looked at my hands. During the recess, Patricia Oakes leaned close to me and said, very quietly, "When exactly were you planning to tell me the full details of this?" "I told you I had documentation," I said. "Frank, I told you it was significant. Frank, I'm your attorney. You're a very good attorney," I said, "and you did a very good job in there on the arguments that mattered. Thank you." She made a sound that was not quite professional and looked away. When we reconvened, Judge Morse took her seat with the deliberate composure of someone who has handled surprises before and intends to handle this one the same way. "I've reviewed the submitted documentation," she said, "and made the appropriate inquiries. I'm not going to speak to the specifics of the materials on the record at this time, as some of what's been submitted involves matters that are under seal. What I will say is that the court has a responsibility to ensure that any custody arrangement serves the genuine best interests of the minor child, and that responsibility extends to the financial and legal stability of the proposed custodial environment. She looked at Gerald Caldwell. Mr. Caldwell, I'd suggest a brief consultation with your client before we proceed further. I'm granting a continuance of 48 hours. Gerald Caldwell said, in a voice that had lost some of its polish. Thank you, Your Honor. Derek left the courtroom before the bailiff had finished saying, "All rise." I heard his footsteps on the marble floor, quick and purposeful. The footsteps of a man with phone calls to make. Sandra sat at the petitioner's table for a long moment after everyone else had stood. She had both hands flat on the wood surface in front of her, and she was looking at something I couldn't see. I thought about saying something to her. I decided the time for that wasn't now. In the hallway outside, Patricia Oakes spoke quietly with Gerald Caldwell for about 4 minutes. I waited on a bench near the elevator and watched the afternoon light come through the tall courthouse windows and move slowly across the floor. Donna Reese called me while I was waiting. I stepped outside. "I heard you used the letter," she said. "I used the letter. That's what it was for." "I know." A pause. "How'd it go?" "I don't know yet," I said. "I think it went the way it needed to go." Another pause. "Frank, for what it's worth, you built a clean case. Everything you gave us was solid. Whatever happens to him legally, you put together good work," I said. "His stepson is 10 years old and misses his father. That's what this was about." She was quiet for a moment. "I know," she said. The continuance lasted not 48 hours, but 19. Gerald Caldwell called Patricia Oakes the following morning. His client, he explained, had concluded that relocation to Phoenix was no longer feasible given certain business considerations that had recently emerged. Sandra was voluntarily withdrawing the relocation petition and the sole custody motion. She was, however, requesting a formal custody agreement that would codify her primary physical custody while establishing my visitation rights clearly and legally. Patricia Oakes called me afterward and read me the terms. Primary physical custody would remain with Sandra in Columbus, no relocation. Visitation for me. Every other weekend, 6 weeks in summer, alternating major holidays. All major life decisions regarding Tyler's education, medical care, and extracurriculars to be made jointly by Sandra and me, with a mediator for disputes. A standing provision that my visitation schedule could not be modified without court approval. I sat in my kitchen and read those terms again on the paper Patricia had emailed me. Every other weekend. 6 weeks in summer. A seat at every decision. I had not expected her to give that much. Patricia Oakes told me later that Sandra had called Gerald Caldwell the night before the continuance expired and told him she wanted to make a deal. That Sandra had spent the evening looking through photographs of James. Tyler had found them in a box and shown her, and that she had called Gerald Caldwell and said, simply, "I want to do the right thing." I don't know if that's the whole story. I don't know what Sandra was thinking in those hours or what she understood about what was coming for Derek, who was, in fact, charged federally 6 weeks later and whose assets were frozen 11 days after the charges were filed. I don't know what she was thinking about her own role in those finances, about what she'd signed and what she'd known. Those are questions she was going to have to answer in a different kind of room than the one we'd sat in together. What I know is that she agreed to the terms. And that she kept them. The first weekend Tyler came to stay with me after the agreement was signed, he arrived on a Friday evening in November with a backpack and a duffel bag and a confused expression. "Mom said you did something," he told me, dropping the backpack on my couch. "She said you worked really hard for a long time to make sure I could stay." I said, "I wanted us to be able to do this." I gestured at the couch, the television, the kitchen where the frozen pizza was already in the oven. He looked at me for a moment. He was 10 years old and he had his father's eyes, and sometimes that still takes the breath right out of me. "She also said you wore a plaid shirt to court," he said. I laughed. It was the first time in a while that I'd laughed without thinking about it first. I did. Why? I thought about how to explain it to a 10-year-old. About how sometimes the most powerful thing you can do is let someone underestimate you. About how 28 years of chasing people who thought they were smarter than the system had taught me that the system itself, when it works the way it's supposed to, doesn't care what you're wearing. About how the man across that aisle had spent the whole morning looking at my shirt and had never once looked at what I knew. I said, because what matters is what you bring to the room, not what you wear to get there. He thought about this. That's kind of like something Dad would say. He was a smart man, your dad. Yeah. He pulled his feet up onto the couch. Can we watch the game? Already got it on. We watched football. We ate frozen pizza. He fell asleep before the fourth quarter and I didn't wake him up, just got a blanket from the closet and put it over him and turned the television down low. I sat in that living room for a while after he fell asleep, listening to him breathe, listening to the wind outside and the particular quiet of a house that has something worth protecting in it. I thought about James. The way I do most days, not with grief anymore so much as with a kind of daily acknowledgement. The way you nod to someone you know when you pass them on the street. I thought about the flannel shirt hanging on the back of the bedroom door, doing exactly what I'd needed it to do. There's a version of the story where I'm a hero in it, where the old man outsmarts the slick lawyer and the fraudster and walks out of the courthouse victorious. People like that version. I've noticed that people want a story with clean edges, where the bad people lose completely and the good people get everything they deserve. Real life doesn't do clean edges. Sandra is working through something that I can't imagine and didn't wish on her. Tyler still asks about Derek sometimes, with the honest confusion of a child who doesn't understand why adults make the choices they make. Derek's trial is moving through the system slowly, the way those things do, with lawyers and continuances and motions that don't mean anything to anyone outside the courtroom. What I have is Saturdays at Hoover Reservoir. What I have is a 10-year-old boy who calls me on Wednesday nights just to talk. What I have is the standing provision, legally documented and court-approved, that I will be at that table for every decision that matters for the rest of his childhood. James would have found the flannel shirt funny. He would have said, "Dad, you can't do anything like a normal person, can you?" He would have been right. I wore a $12 flannel shirt to the most important day of the last 3 years of my life. And the man who laughed at it is now navigating federal charges, and I am sitting in my living room watching my grandson sleep on my couch, with a 6-week summer visit already on the calendar and a fishing trip already planned for the first week of it. I did it for Tyler. I did it because James can't be here to do it himself. I did it because 28 years of following money through the dark taught me something that Gerald Caldwell, for all his expensive suits and polished sentences, had never learned. What you wear to the room doesn't matter. What you bring to it changes everything.